Welcome to the CAJO's Caribbean Law and Logic series, where we explore ideas of law in conversation with eminent jurists and other persons in the profession. Today we have the privilege to interview the Honourable Justice Burgess as he retires from the Caribbean Court of Justice. A little bit about the CAJO. The CAJO is a regional organization that brings together judges, magistrates, and other judicial officers from across the Caribbean. Its primary aim is to promote judicial excellence, independence, and the rule of law in the region. Our guest today, Justice Burgess, is a Barbadian national. He's been a judge of the Caribbean Court of Justice since 2019. Before that, he was a judge of the Court of Appeal of Barbados from 2010. He is internationally recognized as a jurist and served as a judge on the Inter-American Development Bank's Administrative Tribunal, serving as both vice president and then president. He later joined the World Bank Administrative Tribunal, again serving as vice president and president. He's a former dean and professor of the Faculty of Law of the University of the West Indies. And in fact, he was and remains the longest serving dean. He has been honored by the University of the West Indies for his contributions to law and to education. In fact, he is the author of two well-known publications, Commonwealth Caribbean Company Law, which is a standard text at the Faculty of Law in the Caribbean, and also the Law of Corporate Receivers and Receiver Managers. In addition to these two texts, he's written numerous articles on areas of law, specializing on areas of corporate law. Andrew, if I may, thank you so much for joining us today and spending this time with us. And what we want to do is just chat a little bit with you, ask you a few questions, and get your responses, really to share not just with all Caribbean judicial officers, but also with all of the CAJO membership. And the CAJO membership includes academics, students, and international persons who are interested in the development of law and the Caribbean. So maybe let's start a little bit.
Before you start, Peter,
yes,
you must give me an opportunity to say thank you very much for organizing this occasion. I think the work which you are doing with CAJO is important. And for me, putting forward my ideas before your audience, I think is something which I welcome. So thank you very much for organizing this event.
Yeah, no, you're very welcome. And I'm sure to all of you who will look at this, we will all come to see why sharing this time with Andrew, as I will call him, Justice Burgess, when you appear before him in court, but for today, Andrew, why spending this time with Andrew today is going to be meaningful for all of us. And so just a bit of reflections on your judicial career, Andrew, and maybe we can start with, what motivated you to pursue a career in law, and how did that journey end you up first in the Court of Appeal and now here?
Peter, that's a good question, and I'm certain you will see that it was a winding road that I traveled towards law. First of all, I'm from a country district in Barbados, and at that time, the legal profession and the medical professions were the only professions that meant anything to us youngsters. So I started out thinking I would love to become a lawyer. But when I got into sixth form, I studied French and came across the French philosophers like Camus, Henri, Sartre. And after that, I thought of myself as being a revolutionary. You wouldn't believe it, but that's how I saw myself. And actually applied and was accepted at Howard to do a degree in political science, philosophy, and sociology. My dad at one point in time looked at me and said to me, now after you finish that, how are you going to support yourself and anyone else that may join you? So as luck would have it, the Faculty of Law had started in Barbados in 70, and this is 70 when I had the conversation with my dad. So I decided, okay, I'll apply for the Faculty of Law, and I was accepted in the Faculty of Law, and that is where my legal journey started. But
So, if I may interrupt, so that if you had
yes.
gone to Howard, you may have ended up not at the CCJ, but in a prime ministerial position somewhere.
Well, I wonder. Now, the thing about it is that I toyed with politics in 1986. The late Errol Barrow was trying to interest me in contesting a constituency in Barbados. I have to say to you that if I had won, I would have not lasted very long in politics, because politics was not, it involved intrigue, which I didn't feel comfortable being a part of. So I would not have, succeeded in politics. It just didn't appeal to me.
Yeah. So you're telling us about your journey. So
Oh
you
yes,
got into
my
the
journey
faculty.
continues.
Yes.
My journey continues. So I finished my degree in law at CAJO, and was planning to come to Trinidad immediately after completing my LLB. Unfortunately, or fortunately, I got involved in an accident and got both my legs broken. So I ended up at the hospital, and Professor Carnegie, who was the dean of the Faculty of Law, came to visit me on one occasion and said to me, "Well, you can't go to Hugh Woodin Law School now. So will you do a bit of teaching in the Faculty of Law?" So I thought that was not a bad idea, and I went to the faculty, first as a tutor, and then they offered me a contract as a lecturer. And I spent the next over 35 years in the Faculty of Law.
But isn't it interesting in life? Because we look at the end point, and we don't appreciate the nuances in the journey. Isn't it interesting in life how an accident turns into a career?
I couldn't agree with you more, Peter. I wouldn't, if I'd gone to St. Augustine, to Hugh Woodin at that point in time, I wouldn't have met my wife. My kids would therefore not have been.
Yes.
And that's perhaps the most important things in my life. I would have gone into private practice. Perhaps I might not have met you.
Yes. Yes.
And the other persons in the Caribbean Court of Justice. So I agree with you. I mean, these things which we view as just accidental could very well be sprained from a deeper purpose, but I don't want to get involved in that.
But I think it's important, because some of the people who are going to look at this are going to be young professionals in the legal profession and otherwise, and we all go through sometimes stages in our career where we think, I'm planning to do this, but it isn't happening, and we could become a little, maybe even depressed.
Yes.
But I think stories like this that demonstrate that sometimes the way life unfolds, what starts off broken legs, to be something that is, oh my goodness, bad news, can bear such good fruit.
Yeah, well, just I don't want to prolong this discussion, but just to say to you that I'm satisfied, and I've said to any person who would listen to me, and not a lot of persons listen to me, but anyone who would listen to me, I would always say that the greatest thing that ever happened to me was having two broken legs and not being able to come to Trinidad when I, intended to come to Trinidad.
Yeah, very, very interesting. Thank you so much for sharing that with something that's intimate in your life. Thank you for sharing it with us. So you end up in the Court of Appeal, and maybe just to spend a little time on that shift from a career in academics as a teacher with students. What attracted you or motivated you to want to make the shift onto the bench and, of course, to end here at the CCJ?
Excellent question. Excellent question. Now you have to remember the time at which I went to the Court of Appeal in Barbados. I was in my 60th birthday. Within the university, I could have continued for 5 more years. But the point is that I had been writing about how law should develop, how jurisprudence in the region should develop for all these years. I mean, over 35 years I was involved in that. Now, so an opportunity arose to actually attempt to develop jurisprudence. And so at age 60, I was ready for the Court of Appeal in Barbados. And the reason why I was so anxious is because I believed that I had developed enough experience to make a contribution to the development of the real development of law in Barbados and beyond.
Yeah, I like the way you talk about, the real development, because one of the things that we quickly come to terms with as judges is that the work we do affects real people and real lives, So if we shift focus a little bit and we think about you're at the point of retirement, just about retiring, if you have to now look back at your judicial career, could you share with us what, given the transition, and you shared with us why, what would you say are some of the defining moments, whether in the Court of Appeal or the CCJ, what would you say are some of the defining moments for you of your judicial career?
Yeah, good question, Peter. I would say, first of all, that the biggest boon for me in my judicial career is my appointment to the Caribbean Court of Justice. I mean, that dwarfs everything else, and you can understand why. Because devoted as I was to arguing that there should be Commonwealth Caribbean jurisprudence, it's one thing to publish in journals and no one really reads about it. It's another thing to actually make decisions. And when you make the decisions, persons have to treat them or be part of making the decision. Even if you don't make the decision yourself, be part of making the decision. And persons have to view the decisions as precedents. And so you have an opportunity to make a contribution, whereas writing in a journal, you may be cited by other legal scholars and so on, but that doesn't take you very far towards achieving what you really want to achieve.
So I'm going to put some words in your mouth and provoke you a little bit, because this shift seems to be a shift in which we're moving from thinking about and writing about what should be and what could be to, would you say that you, as a judicial officer, that we make law? This debate between, we interpret and apply, but we don't make.
Yeah.
What's your take on the reality of that?
Making, yes. Yeah. If you permit me just to deal with one case in particular, and it's not a CCJ case, it's a Court of Appeal in Barbados case. I think everyone knows the decision, the House of Lords decision in American Cyanamid. Anyone who doesn't know that hasn't gone close to a court for an injunction or anything of the sort. But I always thought that the House of Lords was wrong in that decision. And as fate would have it, one of the first cases that I came across adjudicated in Barbados was a case called 2Js Limited and West Haven Limited. And it's a case where the question of a American Cyanamid injunction was involved. Now, I was bold enough to write a decision which I would think nuanced the American Cyanamid. As a matter of fact, that's what I think. I mean, that it was nuancing the American Cyanamid. And that case has now become the leading case in Barbados. I've seen it cited in the OECS as well, but certainly in Barbados, no one goes talking about an injunction without talking about the 2J's decision.
So we judges do make a little bit of law.
Well, that's the point. And
Yeah.
yes, but
Yeah.
there are two birds I was killing with that stone. One is that yeah, you make law. You make law. It was made for us by the House of Lords. I mean,
Yeah.
there was a time when it was made for us by them. But the point is that you make law, and you have an opportunity when you're sitting in the court to actually make law. You could write until the cows come home when you're an academic. But that, I think, was something that I treasure very much. That decision,
Yeah.
I treasure very much.
Yeah.
And it's referred to going and coming in Barbados.
And I hear resonances in that we'll come back to in a little while. If, for the people looking on, here is a person who is obviously in you, lived a very distinguished life, a very accomplished life. I've shared some of your accomplishments. But for you, if you have to think about what would you like to be most remembered for in this judicial career, what from a personal point of view, but maybe a personal professional point of view, what would you like to be remembered for?
You said judicially. The thing is that you have to remember that my life is a life which is divided basically into two. The academic side of me, academic administrator, academic administrator side of me, and the judicial side of me. I must confess that I loved being with my students so much, so very much, that I must say that I would love to be remembered by them as a reasonably okay teacher.
Well, no, for the record, on Tuesday past there was a special sit-in to celebrate your retirement from the CCJ, and all of the, or much of what came in from contributors was how appreciated you are as a law lecturer, as a professor, and the impact you've had on so many lives. In fact, I think we were told that at least three of the judges on the CCJ bench have been students of yours in the course of time. So I don't think you should question your impact.
Yeah, no, you see, the thing about it is that I remember, and I'll take you back to a part of the discussion we had earlier. I remember, well, when I went to teach in the Faculty of Law, I was 25 years old. So obviously I knew no law. So my students like the late Jeff Comerback, and the now Chief Justice of Barbados, Leslie Haynes. I remember learning so much law from them. They thought they were learning from me, but I learned so much law from them, and generations, Peter, generations of students. I must confess that they may be surprised to learn that I was a student and they were, I benefited so much from them. But so to see so much of them who, argued with me and who discussed with me, to see them at the top of the profession in the judiciaries in the region and so on, gives me tremendous pleasure. And I would, if there's anything I'd love to be remembered for hereafter, is a person who tried to be a legal educator. That's basically.
Well, I for myself, I don't think there's any question that Andrew will be remembered for a long time as one of the most outstanding legal educators in the legal field, anyway, in the Caribbean. But it's a nice segue into what I want us to invite us into now, and because you've said there, you see, that even though you were in the role of lecturer, that you were the student. And one of my experiences of you is what I call your judicial learner's mind. And it's something that has impacted me personally very deeply and struck me that you have this continuous learning approach to the work that we have done as judicial officers. And so let's maybe shift a little bit to talk about legal reasoning and legal philosophy, and to ask you a few questions around that. When you come to deal with what we call complex or novel legal questions, share with us what processes or what approaches you deploy.
Yeah. Well, you see, you said complex legal questions. Uh, they, in my respectful view, can occur in two main guises. It could be complex because of the legal situation, the legal circumstances, or it could be complex because of the law which is involved. You could have a very complex area of law, or you could have a complex situation to which you have to apply the law. Now, uh, in terms of a situation which is factually complex, that is one where one has to be extremely careful. This is, well, certainly working with judicial counsel in the CCJ and to a certain extent in Barbados. This is where you relied heavily, very heavily on your judicial counsel to help you unravel your in a court of record. So you are not, you can't try the case yourself, but you have to do as best you can on the facts which are there. So that's a very intense exercise as far as I'm concerned. The easy exercise, which I mean, you may think you may not agree with me, but the easy exercise is where the law is complex.
Okay.
Where the law is complex, one has the opportunity to reflect on the law, to look at the great judges who've spoken about it, go to the text, the leading text, and so on, and one attempts to unravel it. And yet again, this is where judicial counsel come in as well. When you're in university, it's the research of the research officers or so. But having discussions, certainly from my perspective, having discussions with those that personnel, the judicial counsel and so on, is a very useful way of testing your appreciation and understanding of what the complex legal principles with which you're dealing. So it, for me, whenever we are dealing with a complex legal question, as you put it, one has to see first of all the nature of the complexity. Is it a factual, circumstantial, or is it a one of principle and jurisprudence? And uh, I don't want to bring tales out of school, but you and I have had discussions in respect of these kind of things. I mean, uh, and I think that the more one discusses these things, the better one knows whether one is right or wrong. And the more one can become confirmed in one's wrongness or rightness, as the case may be. So that, Peter, as a judge, that is how I attempt to approach these complex legal questions, and using my fellow judges as resources is for me a critical tool which is to be used.
Yeah, no, I think that, one of the things that I've enjoyed in my relationship with Andrew is, and of course this is sitting at an appellate level, is the collaborative approach to doing the work we do, considering cases and determining what are just and right outcomes. But I think that even for trial court judges, just because some of the people who are going to be looking at this would be first-tier judges who are not at the appellate level. I think that, you know, creating opportunities and having a few relationships with judicial officers, it could be at the same sort of tier as yourself, or maybe even otherwise. But creating a few relationships where you can have conversations, because I think having the opportunity, as you and I have enjoyed and done and practiced, to talk about an issue really helps you even understand your own thoughts.
Yes.
You know, so no, I think that's
Yes, and if I may, Peter, just
of course.
quickly, you gave some advice to the younger judicial officers, and I think that's very important advice. I just want to underline it, which is that there's nothing wrong, absolutely nothing wrong, and everything right about discussing, not necessarily the case. You don't want to divulge confidential information and so on, but certainly finding some person to discuss it with. As you said, you learn so much from doing that, and certainly in my career, such as it has been, this is something which I find to be true, not only in the judicial circles, but certainly in academic circles as well.
And I think it's good advice, because you can, the law is open and you can talk about a legal principle without disclosing the factual nuances.
Yes.
And I don't think there's anything unethical about that. In fact, I think there's everything good about that once you draw the line a little bit.
Yes.
You know? If you had, just to pin you down a little bit, Andrew, 3 key principles because that you have kind of used or deployed consistently over your judicial career when it comes to, say, approaching statutes and statutory interpretation, what would you say are, looking back on your career, have been the sort of dominant principles that you have found most useful?
Okay, you say statutory interpretation?
Yes, or the interpretation of law, but whatever
Okay.
you would like to share with us about.
Yes, this is something which I've thought about and have been thinking about for a number of years. One of the things that we have to remember is that we are operating in the West Indies. We are coming from a colonial background. I mean, as far as law is concerned, that's what we're coming from. And we don't have a legal system which has the kind of history of the common law. The common law is from 12, what have you. So it has been existing for centuries. And this is what has been bequeathed to us. This is, so we have this system, but we were never really the actors in this system. We were merely, we got decisions, got whatever was handed down by the English courts, and we followed it, we applied it, we followed it. Now, I think that we've moved to a more privileged situation. I think that with our independence and the independence of our courts and so on, that we are in a position to develop the common law. I mean, I think that we may have a little bit more to say on that. And in doing so, I certainly find that looking at the principles which have been developed by the English courts are sometimes very useful in approaching the interpretation of statutes, in looking at texts, in assessing the value of a precedent or what have you. I find that I tend to be a little bit more reserved in terms of utilizing those principles. And than you say, for instance, Peter, I know that you're a lot more robust in approaching statutory interpretation than I am, and in dealing with precedents as I am. But one of the things that I would want to reflect on, though, Peter, is that I think that you are right, and I hope that I know that you are questioning me, and I'm not. I'm not in a position to comment, but I think that West Indian judges need to pay a little bit more attention to the society in which they operate in. We have young persons, professors, and so on, who are writing about our circumstances. Now, they obviously will not have the eminence of a Chitty on contract law or McGregor on damages and those kind of things. So we are not going to find those kinds of examples. But we do have persons who are writing. And I think that in developing our law, we need to find some way of accommodating the views of these academics and what I'd call writers of the law rather than judicial officers.
I find that good because for a society in real development, post-independence, what sources do we look to? And what I hear you saying is that in addition to the traditional sources, let's look to, for example, Caribbean academics who are reflecting on these issues and writing. And I think we can do more of that, but I think we're beginning to do some of that. Social context seems to be behind the scenes, as it were, in what you just said. And so let me ask you maybe what...
Just before you ask that question, Peter, just to underline the point you're making, the Privy Council itself, recognized that the local circumstances rule existed from time Adam was a boy, so that we have to
but we are shy about it.
We are shy about it. Yes. We need to remember that this is our local circumstances. That law is not something which abides in the sky. Law is something that operates within society, and even the Privy Council, for all its worth, was able to develop a local circumstances rule from as early as 18, what have you.
So everybody thinks that when it comes to commercial law and contract law, this is one of the conservative areas where stability and certainty and predictability are sacrosanct.
Yes.
You've been a professor in this field, you've written in this field. We have here your 2 books on display behind us. You've been a judge, you've written several decisions in this field. Has your approach to commercial law principles and contract law, has your approach changed the way you have thought about commercial law because of what we're talking about, Caribbean local contexts? Will you share some thoughts on that?
Yes. The problem with corporate commercial law is that it is so entrenched in English common law that it's very, very, very difficult to turn it around. But the point is that even the English common law finds that there are times and there are occasions when the strict law needs a little moderation. Take, for instance, I'll take contract law and take exemption clauses, for instance. The insurance companies and so on, they will tell you sign on the dotted line, and if you have a magnifying glass and you are able to magnify the fine print, you'll see that you've just signed away everything that you thought you were getting. You realize that you haven't got. That's the nature of an exemption clause. But English judges have developed techniques of allowing you to avoid those clauses, those exemption clauses. So even the point I'm making is that even though the common law which we have inherited is stable and so on, there are angles, little angles, which are left to get out of the severity of the operation of the rules. So take for instance, one of the papers which I wrote when I was an academic was on unfair contract term in adhesion contracts, in standard form contracts. That study was looking at the common law to see what angles one could extract from the common law to find fairness and justice for persons, consumers, and so on. So that is what occupies me. It occupied me as an academic. It occupies me as a judge. Yes, it's going to be difficult, but you will find what can I find? What angle can I find to use? You remember in Blairmont, a case where you and I sat on in Blairmont, and we had to look at a term in a contract which looked like a wicked term. It looked like a term that we knew we had to get around. The device of the innominate term. And I have to give it to you. You were the first person who, in my experience, who saw the use of this as a tool for future use in terms of looking for fairness and procuring fairness for persons in a contract. So, okay, so you raise the question: how do I, as a corporate commercial lawyer, how do I deal with the preponderance, as it were, of the common law? That's my angle. The thing is, I'm not as radical as some people I know, but I look at the law has developed, and if there's any opportunity whatsoever if I can find whatever angle I can find, that is what I will latch on to ensure that fairness prevails in the transaction.
Yeah, and it belies another question that I was going to ask you. What are some of your underlying ideologies that you bring to bear as a judicial officer? And you've already touched on one. When you say fairness.
Yes.
Fairness.
Yes.
As a fundamental principle that drives you, the way you think as a judicial officer. So would you agree that for you fairness is one of the core principles, and if so, are there any others that you would like to share with us?
Yes, I think you're right. From as a West Indian trained lawyer, it's difficult. And as a man who grew up in a West Indian society where the law wasn't always, and perhaps even now, isn't always friendly to certain persons in society, the law was there to ensure that persons within society behaved in a certain way. Now, obviously, studying law and researching law, one could not help but recognize that fairness had to be one of the leading lights that one would follow in approaching law. So I agree with you. Fairness and justice are two principles which inform all of my writing. If you look at my academic writings, most of them are tending to this question of fairness and justice. There's one occasion when I did a case in Barbados, a case called Ward and Walsh, and it was appealed to the CCJ. The CCJ upheld me on the hard law, but when it came to I thought there was one part of the judgment where some person, one of the contractors had done some work and so on, and I thought that I would look to equity to see if I could find an equitable compensation for the work which the person had done. I was castigated by Sir Dennis Byron, who is, as you know, excellent jurist, and he was right. But there was I left hanging, but looking for, I knew it was wrong, but looking for an angle and hoping that the CCJ would have upheld me, and thereby, we would have had another mechanism which we could use in a situation where a person has obviously contributed to the development of property or what have you, but did so in the wrong. So,
and it's interesting because, one of the things that has always struck me about you as a human being is that you are basically a person who thinks about the other, cares about the other's well-being, and in your day-to-day living tries to empower and encourage and protect others. And I think part of what I'm beginning to hear as we chat coming out is how that human element in you is also part of what informs how you're oriented around law within the principles of law and within the rules of law. But there is this impulse to fairness and to justice, which is very, very interesting. Let me ask you to just throw your mind into the future a little bit and a little bit of imagination, maybe. Do you see looking into the future, any significant changes in development in, first of all, commercial law, contract law that you kind of see on the horizon? Where the law is on the verge of a shift, maybe. Do you see anything like that? Or if not in commercial law, in any other areas of law, any kind of breakthrough areas that you sense are coming?
but if you're talking about law is being developed by the CCJ, I would say to you that I am entirely encouraged by the CCJ's efforts in constitutional and public law. I think that because the system is not overburdened by common law when one is dealing with modern West Indian constitutions, the court has a lot more latitude to import its ideas into the making of West Indian constitutions. And I think that, I don't want to specify any judgments as such, but just as a general principle, and as a so-called student of West Indian jurisprudence, I can say to you that from my perspective, I am very heartened by the court's developing of our constitutions. And I think that this augurs well for the future.
But Andrew, there are naysayers who say this is an activist court. This court is sort of overreaching, Leave that for Parliament. Don't go too fast, too far. How do you? What are your thoughts on that?
My thoughts, Peter, is that I'm not going too far, too fast.
Right.
I mean,
Yes.
if I had to describe myself, that's how I would describe myself.
Yeah.
But this is in certain areas.
Yes.
When you're dealing with something as fundamental as constitutions and something which is which has a history, this thing is coming with a history. It's not coming, without all the things that went with our societies as they labored on the English colonialism, and one doesn't want to sound political, but at the same time, one lives in a society which is a real society and which is emerging from a certain history. And I think that a court like ours, which does not recognize the history it's coming from, on the basis that you said going too fast, too far, I, I think that that would be very wrong. Now, on the other hand, I think that the common law is ponderous. That's how I would refer to it. And for me, I think that the court has to develop the common law for our people, but it has to develop it very cautiously.
Yeah.
Very cautiously.
A more incremental.
It's more incremental.
So, yes.
Yes. And the other thing as well, Peter, is that the common law system, which we have been handed down, depends upon case law.
Yes.
And there are so few case laws, cases which we are deciding, that we have to be very careful that every time we decide a case, the case does not create dissonance, because you do not know, we do not know when the next case will come along that we can correct, that we can correct it. So from my perspective, I think that in the original jurisdiction, in relation to constitutional and public law, I think that that our courts are very well positioned to dictate the pace at which these things happen, because of commercial interests and so on. I think is a little bit more difficult in terms of in those terms. And if I may quickly say, because I'm remembering the case of Lalushan, and I'm remembering how we, in that case, how the court in that case attempted to recognize the happenings of the realities of our society, and write the law in such a way that it recognizes the reality of our situation. So I think that there are areas where the court can move a lot faster than other areas. Yes.
As we kind of wind down a little bit, would you say that for yourself, you have evolved as a judicial officer in the way in which you have thought about how you do the work of a judicial officer over time? I mean, looking back now that you've spent many years in the Court of Appeal and then significant amount of time here at an apex court.
Yes, yes, that's a good question, and I'd say to you, yes, that I've evolved, and I suspect that I'm still evolving.
Yeah.
No, I can promise you that that because I'm leaving this court doesn't mean that I'm not going to be writing about things West Indian about West Indian jurisprudence. I certainly will be, and the experience which I've had in this court, because I am of the firm view that this court is, the judges in this court are as good as the judges anywhere in the world. I certainly have read Canadian cases, I've read Australian cases, I've read English cases, and I think that our judges are as solid as the judges anywhere in the world. But to answer your question, evolution, I'm still evolving, and you will see my evolution in my.
Well, are you going to share with us what does the future of Andrew Burgess anticipate in terms of future endeavors, whatever those may be?
Yes, the French, they have a way of saying plus ça change, plus c'est la même chose. I say what goes around comes around. I have every intention of doing some teaching.
Lovely.
Of doing some teaching.
Yes.
That's what I intend to do. I don't know if the deans and heads of departments will have me. They may very well think that there's nothing I can add to.
I very much doubt, but yes.
Yeah. Anyhow, but that's what I planned. To. I've started talking to a couple of the deans already about doing some work with the young minds which are there now. But certainly, writing.
Yeah.
I will definitely begin writing from Monday. And I have the have the assurance of assistance from
Yes.
some persons to help me in my
Well, both publications are due for a
For-
little updating. I mean, I think the time would have been constrained because of the judicial work, which
yes,
takes a lot out of us,
yes,
But now that retirement may give you some time, because I'm sure the Caribbean community, legal community, can only benefit from updates and the sharing of your new thoughts and views and ways of looking, and so
yes.
some of that.
I hope they can benefit, but
Yeah,
I can
absolutely.
promise you whether they benefit or not, the books will be there.
Right. So,
So,
so you're
so
thinking about doing some updating.
definitely,
Good.
definitely, and
Yes.
rewritings.
And rewriting. Yeah.
Yes,
Yeah. Yeah.
the book on corporate receivers and
Mhm.
receivership.
Yes.
What I plan to do is to completely revamp that.
This is the first
The first
book,
book,
right?
yeah,
Yes.
completely revamp that.
Right.
I will update
Yes.
for the time being, but what I'm hoping is that within the next 2-3 years that to rewrite the book on company law completely.
Okay.
Yes.
Yes. Good. Good.
Yeah.
So, looking into the future, young or new attorneys, new judicial officers, any sage advice to them? Maybe focused on maybe their careers or how they develop Caribbean law or anything looking
Yes.
into the future. What do you say to them?
What I'd say to young students, young lawyers, young judges is that the most important thing is to recognize that hard work is going to be involved.
Mhm.
You have to, one has to be prepared to um, to do the hard work. Collaboration, I think,
Mhm.
is something which is crucial. Uh, you must not afraid to be wrong.
Mhm.
You
That's something you've said to me from the time that we've known each other at the CCJ.
yes,
It's one of the things I admire in you, your courage in the sense of, this is what I think, this is what I have reasoned, and the preparedness to put you down.
yes, yes.
Yeah.
I think that for
Yeah.
young students, young attorneys,
Mhm.
young judges, that
Mhm.
that is crucial. You have to have the courage of your conviction.
Yes.
But critically important is that you must be prepared if there's a superior
Mhm.
view
Mhm.
to say, I, 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 I'm wrong. I think you're right, and
Mhm.
I'm gonna, go along with
Mhm.
the view
Mhm.
which you are exposing.
Mhm.
That's fair.
Which is what we call judicial humility. Which is
Yes,
a sort of intellectual humility,
yes,
which
yes.
is
That's a crucial trait
yeah,
which persons
yeah,
must have. I mean, you have to be prepared to listen, to see the weaknesses in your argument. But hard work is very
yeah,
important,
yeah,
as you will know.
yeah, yeah.
Yeah.
No, good. Um, Suppose you had gone to, was it Howard or Brown?
No, Howard.
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 Any, as you look back, any reminiscing about, you know, maybe, but maybe more importantly, what I want to ask is, do you see that impulse to political science, which even if it didn't
Philosophy
philosophy,
more than yeah.
yeah, do you see that impulse, even if it didn't come to fruition in that context, has continued to live on in you and inform this whole life in the law and this career as a judicial officer?
I think so. I think it does. I mean, the interest in pursuing law and
Yeah.
looking at jurisprudence. I mean, if quite a lot of what I used to write um, uh, had as the backdrop jurisprudence, which is
Mhm.
another form of
Mhm.
philosophy.
Mhm. Mhm.
Um, Even now,
Mhm.
in
Mhm.
writing judgments, at the back of every judgment is a philosophical
Mhm.
position.
Mhm.
So uh, I don't know that doing pure philosophy would have fed me. and my family. But but
but it feeds
but
the way you think and do your work.
it feeds the way I write and the way I think,
Yeah.
and I think that that's a good place for it to be.
Yeah, and it's a good place for us to end because it's something that I have experienced in my professional relationship with you. That at the end of the day, Andrew, the academic, the professor, the judge, has been very deeply Andrew the philosopher. And I think that we all uh, should be, and we all are deeply grateful, Andrew, to you for, first of all, I was going to say for breaking your legs, but that doesn't sound like a good thing to say, but for choosing ultimately to end up doing law and to spending this time in law and to bequeathing to us, Caribbean people, your writings, your thinking, and we look forward to your future endeavors. So thank you very much. And I'm going to give Andrew the last word. But to those who are viewing and seeing this, we hope that you have found it not just interesting, not just informative, but in some way inspiring and maybe even um, formative as you consider your life and your careers, whether in the legal profession or not. So Andrew, I'm just going to ask you to speak to your viewing audience and share your last thoughts about anything.
My last thoughts are these. I'll thank Peter very much for organizing this interview. I think that the idea of having these podcasts is an excellent idea. The thing is that just to share with you that I knew Peter a little when he was at Cave Hill, but I knew more of Peter when I was writing this book on company law. Peter had delivered a judgment in the High Court. He was not even a judge of appeal at that point in time, and I cited he's cited in that book fairly extensively. I mean, for work which he did on company law. A lot of persons might not know that Peter has those pretensions, but the thing about Peter is that he's an excellent lawyer. And when I think of Peter and the other CCJ judges that I worked with over the last couple of years, I have to say that I think that Commonwealth Caribbean jurisprudence is in extremely good hands. And I can only wish CAJO and the CCJ all the best in the future. Thank you very much, Peter.
Yeah, so thank you all very much. And thank you to Andrew and to all those who have made this event, this recording, a success. Thank you all.